did you just send an order in to set it? There was no motion in the file to set.
The motion was filed to set. I looked at the docket entry, Judge. I don't know. I don't remember.
Let me assure you one thing. I've read through the file. There is no motion to set the trial.
That her first notice that this final decree had gone down was when she was served with the complaint for contempt by Child Support Services in October of 24.
Today's courtroom opens with chaos over notice, no-shows, and a divorce finalized without one spouse present. Motions vanish, lawyers withdraw, and dates don't line up. Is this due process failure or strategic silence? Buckle in for contradictions, custody stakes, and equity battles. Subscribe, like, and share for courtroom drama starting now.
Your Honor, we're about to ask the court to set aside the final decree due to lack of notice to Ms. Wood. At the time the motion to set for trial was filed back in September of 2021, it was set, and at that time, the notice was sent to Jennifer No as attorney for Ms. Wood. Ms. No filed a motion to withdraw, which was not heard before the motion to set was heard. The motion to set was set on January the 3rd of 2022. The docket for the court shows that it was a no-show, that nobody showed up on that day. Then, 1 year later, in March of 2023, there is an order to set this for a final hearing. And it reflects that it's for a July 23rd, July 6, 2023 date. I'm sorry. Yes, the order to set date for final hearing says that it's going to be set on July 6, 2023. But it reflects, even though it wasn't filed, oh, I'm apologize. I did that. I said 1 year later. It wasn't. I apologize. It was filed by the court on March 6, 2023 for a court date signed by the court on February the 28th, 2023. But the court looks at the docket January 3rd, 2022. So it was 1 year later. I was correct when I spoke earlier. There was a no-show. Nobody showed up for that motion to set. So no one was here to get a date from the court, but an order was then filed by Mr. McNabb's office, and it says it was sent to Heather Wood. This was subsequent to her attorney withdrawing, but it was sent in care of her father, Craig Martin. We have him here today. He did live at that address at that time. He has subsequently moved to Florida, and he flew in yesterday to be here today. But he will state that he did not ever receive anything at that address for Miss Wood concerning this divorce. They also, in the final decree of divorce, state they mailed it to that address. Again, Miss Wood would testify, and her father will testify, that it was never received at that address. At the time the motion was filed to set it, she had counsel. Counsel obviously did not appear on that date either, so I can only assume that counsel did not get the motion. Counsel subsequently withdrew. Then subsequent to her withdrawal, there was the order entered 1 year after it was filed, or supposedly heard by the court, setting it for a final hearing, and Miss Wood was not given notice. So we're asking the court to grant our motion to set aside. I would further state my client will testify that during this time, yes, she knew that a divorce was pending, but that her and her husband were having meals together. She was seeing her child on a regular basis, that everything was going along. She did not know that the husband was pursuing this divorce or that anything was going on, and she was not represented by counsel. So based on the sole fact that an order was entered setting this case when no one appeared in court on the day of the motion, we're asking the court set aside that final decree.
Don't leave yet.
Sorry, Your Honor.
If I understand correctly, there was a motion to withdraw. There was a motion to set for trial and award of primary custody of the child that was set for January the 3rd of 2022.
Yes, Your Honor.
January the 3rd of 2022, there was a no-show. No one showed up.
Yes, Your Honor.
Then on February the 22nd, a motion to withdraw was filed by Jennifer No, who was representing the wife at that time, and it was set for hearing March 30th of 2022. And it shows that March 30th of 2022, that motion to withdraw was granted.
Yes, Your Honor.
And the order was entered on March 31st. Then no activity occurred until March the 6th of 2023. And on that day, it was an order, simply an order to set the final hearing. And that was entered by me on the 28th day of February. It was not filed until March the 6th. And there was no motion to set the case for trial according to the court file. It just appeared it appeared on an order was entered, but there was no motion to set the case for trial, and an order was just submitted, and it was signed off on me, and I don't know whether it was signed off on the 28th day of February. There is no hearing shown in the court records of a hearing on February 28th, so apparently it may have just been an order to set the case for trial submitted to the clerk without anything else.
Correct, Your Honor.
All right. And then it was set for a hearing, and that was sent to Heather Michelle. According to this, there was a copy sent to Heather Michelle Woods, care of Craig Martin, on at the address shown on Shahan Road in Ashland City, and that was mailed out on the 17th day of February. So is it your position that on the 17th day of February, your client, or thereafter, your client never received that?
She never received that. She'll testify that her first notice that this final decree had gone down was when she was served with the complaint for contempt by Child Support Services in October of 24. And up until that time, she'll testify that she was having dinner with her husband occasionally. She was visiting with her child, that they were just going on with their daily lives, and she did not know that he was pursuing this divorce.
All right.
Thank you.
McNabb, you want to respond to any of that?
Judge, this motion is, I assume, is a Rule 60 motion. 14 months after or 16 months after the entry of the final decree. Assuming Ms. Crabtree is alleging some sort of fraud, it has to be filed within a year, so that grounds out. The other issues, whether or not she was served, papers were sent to her address. Testimony from the son's going to reveal that they talked about this. She knew the divorce was over. The husband's going to testify that she knew the divorce was pending. She had from March of 28th, February of the motion relieving counsel was 3/30, March 30, 2022. She knew at that time that the divorce was pending. She had a chance to get counsel. She didn't. I mean, the case law is replete on the issue of what she's trying to assert. It's just, she hadn't been denied due process, Judge. I mean, she got a copy of the order. I mean, if this were allowed, anybody who got a judgment could say, I didn't get a copy of it.
How did this case get set for trial? Did you just send an order in to set it? There was no motion in the file to set.
The motion was filed to set. I looked at the docket entry, Judge. I don't know. I don't remember.
Let me assure you one thing. I've read through the file. There is no motion to set the trial. There's no motion.
There is. There's a motion set for trial.
Pardon?
Set it for, the motion was filed on the 28th of September to.
Yeah, there was a motion to set the trial in September of 2021, but the order went down 2 years later, or a year and a half at the latest. So,
Judge, assuming that's true. So, I don't know. I don't know what happened. I looked at the docket. I mean, again, one would assume that I'm trying to commit some sort of fraud.
I'm not accusing you of fraud, Mr. McNabb. What I'm saying is that normally there's a motion to set a case for trial. And that way, both parties are notified that it's going to be presented to the court to assign a trial date. Then both parties can be present if they choose to. In this case, the motion to set was filed in September of 2021, and it was no show. There was no one showed up for it. Then a year and a half at least later, in March of 2023, a simple order to set the date for a final hearing was submitted, apparently mailed in, and it was put into the file that I have to sign orders. And so an order was signed setting it for a trial, but there was never a hearing on the motion to set the case for trial. And that concerns me. I'm not saying you did anything fraudulent. I'm just simply saying there should have been a motion to set filed in March of 2023 prior to the court assigning a trial date. It actually would have been February of 2023 because that's when the order was actually signed. It wasn't filed until March the 6th.
I don't know how a trial date would possibly be secured. I don't know, Judge. I can't answer that question. All I know is that the case was set for trial if she didn't know about it. If she didn't know about the trial date, it still doesn't make any difference. She got a copy of the final decree. And the final decree was final for 16 months before she took some action against it. So that's really the core of this question is from what she seeks a remedy is not from the motion to set or not to set or have a trial date. The remedy is from the final decree. The court heard the case, for the divorce, signed the final decree. That's what she's seeking remedy from. And she's had a copy of that. It was mailed to her at the address that was provided not only to me, but to her lawyer, because the lawyer filed her motion to withdraw and sent it to the same address. No new address was ever given. I comply with the rules of procedure by sending her a copy of that. Testimony is going to be that she knew about it. She knew about the divorce. And that's the remedy she's seeking. Set aside the divorce. And it was heard by you. So we had a hearing.
All right, Ms. Myers, you want to put on your proof? I'll hear your proof.
William Craig Martin, Your Honor, he's my witness in the hall. And how do you know, my client, sorry, Miss Wood?
She's my daughter.
Did you know that her husband had filed a divorce from her?
No, I did not.
Okay. Have you ever at the address on Shahan Road received mail for her from Mr. McNabb's office?
I have not.
So are you aware of any documents that have been sent to her concerning the divorce?
No, ma'am.
No further questions, Your Honor.
Hold on.
Were you at any of the hearings in this case?
No.
Okay. You're aware that your daughter had a hearing earlier, right after the divorce was filed?
No, I was not.
Okay. So did you ever receive any correspondence from her lawyer at your address?
Not that I know of, no.
Okay. Not that you know of.
Nothing that I had seen
Okay.
or nothing that I had touched.
Did your daughter live with you at one point in time?
Yes.
Okay. When did she move?
I'm not sure when.
I'm sorry?
I'm not sure when she moved.
Okay. She ever received mail at your address?
Sometimes she did, yes.
She would go to the mailbox and get her mail and open it, so you wouldn't have any idea whether she got a letter or not.
Well, she probably wouldn't go to the mailbox very often, but I would just bring the mail in.
Okay.
And if it happened to be hers, I probably wouldn't pay any attention. I'm not going to look at her mail.
There you go. So something could have come in addressed to her that you didn't know who it was from and gave it to her.
I guess possibly.
All right. Okay. So you can't state under oath that she didn't receive any notification of a divorce hearing because you never did open any of her mail.
I did not.
Thank you.
Just to be clear, Mr. Wood. I'm sorry. Just to be clear, Mr. Barton. After she moved from your residence, did she receive any mail from an attorney?
No, ma'am.
No further questions.
Hold on just a second. I have a question for you. What is your actual street address?
My current address is 424 Bimini K Circle, Vero Beach, Florida.
Back at the time that this was going on, what was the address on Shahan Road?
1365 Shahan Road, Ashland City, Tennessee, 37015.
And when did you relocate from that? When did you move?
I moved February 22nd of 2025.
All right. So in 2022 and 2023, you were living at that 1365.
Yes, sir, I was.
And if her prior attorney, Ms. Jennifer No, had filed a motion to withdraw, and she shows that she sent that to your daughter at 1365 Shahan Road, Ashland City, Tennessee, 371015, that would have been where she was living at that time? That would have been back in
Yes.
February of 2022. I'm sorry, February 22nd of 2021. Was she living with you then?
I don't remember. I can't say that with it being 2025.
How was your mail received at that address? You have a
Yeah,
mailbox?
mailbox. Yeah,
Okay. Out by the road or on your
it's
house?
out, yes, it's out by the road.
Did your
but-
daughter ever receive the mail and go check the
Very
mail?
seldom. Most of the time, my grandson usually went to the mailbox and got my mail.
All right, thank you. Now you can sit down.
I call Heather Wood, Your Honor. You could have a seat.
At this moment, testimony shows counsel withdrew, notices mailed, and a year passed silently. Legally, service by mail triggers presumptions, but fairness questions linger. If no one appeared for the motion to set, can an unsigned gap justify a later final hearing? Should technical service outweigh lived reality here today?
What if you raise your right hand and be placed under oath?
Yes. Please state your full name for the court.
Heather Michelle Wood.
Ms. Wood, you're not denying that you were made aware that you were served with a complaint for divorce, correct?
Yes, ma'am.
So you knew a divorce was pending,
Correct.
and at that, initially you had Miss Jennifer No representing you,
Yes.
and then Miss No filed a motion and withdrew from your case. Is that correct?
Yes.
And that was back in 2021, correct? Or I'm sorry, in 2022.
Yes.
At that time, where were you residing?
At my father's place on Shahan.
And you were aware that Miss No withdrew?
Yes.
Were you aware that they filed a motion to set it for a final hearing in
No, ma'am.
September 21?
No.
Did you go to a court date in the beginning of 2022 concerning the motion to withdraw?
No.
Did you go to the motion for your counsel to withdraw?
No.
After your counsel withdrew, did you receive any other documents?
No, ma'am.
When did you move from the residence?
I moved in 2024.
So in 2023, you were living in the residence.
Yes.
Did you receive any documents from Terrence McNabb's office?
No, ma'am.
Attorney. Okay. And were you aware that this divorce had become final?
No, I was not.
Now, you were living at that residence. What was your relationship with your ex-husband and your child during that time?
Well, Levi came to my father's house every day after school. I picked him up on Monday afternoons as well as Friday afternoons from school at 2:45. He stayed most weekends with me and my dad at that residence. Matt and I talked occasionally when we had things to discuss about Levi. I did show at Levi's birthday party where him and his girlfriend at the time were there in 2023. That was around February 16th.
So y'all were going on your day-to-day life.
Yep.
And you were seeing your child on a regular basis.
Yes.
Okay. Did Mr. Wood ever say anything to you about the divorce being final?
No.
Did he ever say anything to you saying you owe me child support?
No, ma'am, he did not.
Okay. When was the first time you found out that this divorce had happened?
When I was served paperwork for contempt on child support on a Friday afternoon.
Okay, and you immediately retained me, correct?
Yes,
And we filed this motion,
yes.
okay? Now also, so why did you not pursue the divorce or do anything with the divorce?
I didn't have a lot of funds at the time. It was also during COVID, which everything was pretty much shut down for a period of time. He had filed the motion. I was under the impression that we were going to get joint custody as well.
And what gave you that impression?
There was a temporary setting for a motion where I had Levi for 1 week and then he would have Levi for 1 week.
Okay, so that you thought that's what y'all were doing. You were
Yes.
working it out.
Yeah,
But again, at any time, did you know that this final decree had gone down?
absolutely not.
Did you receive any documents from Terrence McNabb's office?
No, I did not.
No further questions.
Mr. McNabb, you may question the witness.
So when did you move from your father's home?
2024,
2023, 2024?
2024, March of last year.
Okay. And so until that time, you were living there and receiving your mail there?
Yes,
Okay. And the address that he gave the judge is the address where you were living?
correct.
Okay. Now, you knew about Jennifer No withdrawing from your case.
Yes,
You got a copy of the motion to withdraw from her, and you got a copy of the order that she got from the court withdrawing from your case. You received those at the address where your dad lived and you lived.
I'm assuming so. I don't recall specifically receiving them though.
Well, you do recall getting an order from her withdrawing from your case.
Not exactly.
I'm sorry?
Not exactly, no. I don't remember receiving
Well,
the
record was
paperwork.
I'm sorry, I didn't mean to interrupt you.
I'm sorry, go ahead.
You may have gotten it.
I could have gotten it, yes.
Okay. And well, you didn't communicate with her for a long time after a certain date, so you knew she wouldn't own your case,
Yes, sir.
right? And you knew the divorce between you and your husband was continuing to be pending because it'd never been dismissed.
Correct.
All right. And when this first started, it looks like, and I've got the date on September the 28th or 21st, 28th, 2021, your husband filed a motion to set for a final hearing and to award custody of his son to him. And we had a lengthy hearing. Is that not true?
Was I present?
You were here when we had a hearing because wasn't this issue about a next door neighbor, a lady, wouldn't it?
Oh, yes.
Jack, I think he's molding the two motions together because the court says no show the date the motion is set for trial. It says no show. No, but there was no hearing on that day. He's asking about two different motions.
Identify the date of the motion, the hearing that you're.
Motion, I'm sorry, I didn't understand what you said, Judge.
You said that she's saying that the motion you're referring to was not on the day of the motion for the court to set the case for trial, that motion was
That
filed.
was the one that I filed on September the 28th, 2021. It was the very first thing I filed.
Your Honor, that motion was set on January the 3rd, 2022, and that's the one the court docket says did not happen.
Judge, there's a document in the file for motion to set and to set for custody. It's in the file. And that was filed on September 28th, 2021. Now,
All right, and
from that
what date
document,
was that set to be heard?
it was heard in front of Judge Mash, Judge.
Your Honor, it was set to be heard on January 3rd, 2022.
That's another
One of
motion.
you talking at a time. there's a motion to set for trial and for award of primary custody of the party's minor child. That was filed with this court on September the 28th, 2021. That's what you're referring to. It was the motion expected to be heard on January the 3rd of 2022. And that was sent to Jennifer No by you by certificate of service. Then on February the 22nd of 2022, and that was to be heard on January the 3rd. The docket in this case shows that there was no show on January the 3rd of 2022.
The hearing he's speaking of was heard on October 3rd, 2019, and the court records reflect visitation with father every other week. That's what it was.
So
That was in 19.
I think that Ms. Myers is correct. The hearing you're referring to is not the hearing on the motion to set. It is a motion that was heard.
Well, there was a motion to set and to have for her. There was two issues, and this is the hearing where she appeared with Jennifer No.
Well,
We had a hearing in front of Judge Mash.
there's no dispute about the fact that there was a hearing and she appeared with her lawyer.
You remember that hearing?
Yes,
And the judge reserved certain issues until the final hearing.
I'm assuming yes.
Okay, all right. So you knew there would be a final hearing at some point in time after that first hearing.
Yes, correct.
All right. Now, you allege in your motion, certain issues about the chronology of the issue. And some of the leads, you recall filing a petition?
Yes,
Okay. And in that petition, you were aware that there was a parenting plan.
correct.
So how did you know there was a parenting plan if you didn't know about the divorce?
Well, the parenting plan I thought was what was the joint custody at the previous hearing.
Well, paragraph 4 of your petition, it says wife was awarded no parenting time with the party's minor children or party's minor child. How did you know you weren't awarded any parenting time?
I didn't know at that time.
Well, it's in your sworn petition that you weren't awarded any parenting time. How did you know that when you signed this?
Stipulate that at the same time we filed a motion to set aside the final decree, we also filed a petition to modify the final decree if the court denies our motion. So we will agree that as of the date of filing the petition, she was aware of the final decree.
Now the contradictions hit hard. Father admits he never opened her mail. She swears no notice arrived. The son recalls calm divorce talk. Each oath collides. This is tension at its peak. If everyone remembers differently, the judge must decide whether credibility or procedure controls the truth behind this vanished notice.
I believe it's a stipulation that she found out about the final decree, and contemporaneously with her motion to set aside that final decree, she filed a petition to modify.
So you in your petition said you seen the child just about every day.
For periods of time, yes.
I'm sorry?
Yes, for periods of time.
Okay. And he's here today. Your 16-year-old son's here.
Yes.
Okay. And isn't it true, or do you remember telling your son that you knew you were divorced?
No, I did not.
You're going to say that you never told him that you knew you were divorced.
That's correct. I did not.
So if he testifies to that, that's not true.
I was never made aware that our divorce was final.
But if your son takes the stand under oath and says, Mom told me about the divorce and she knew
Then
about
he
it,
would
you're
be
going to
lying,
say
sir.
that's a lie.
Yes.
Okay. Do you know when your ex-husband moved to his present address? You know when he did?
I'm not exactly sure, no.
Was he living close to where your dad lived until he moved?
Yes, next door.
Next door.
Yes.
Did your dad and your ex-husband have a relationship where they talked to each other?
Yes.
Okay. Did your ex-husband move from his address next door to your dad before you moved?
Yes,
So you moved in 2024, so it would be before that when they moved, or he moved. He and his son moved.
yes,
His son is living with him,
yes.
or your son is living with him. Is that correct?
Our son was living with him.
Your son, his son was living with him when he moved prior to 2024.
Yes,
And we know that the date that you remember. Prior to 2024, he moved.
yes,
Okay, that's all. Thank you.
Just to be clear, Ms. Wood, the hearing in which they did the 50-50 parenting time was 2019, correct?
yes, that's correct.
And then secondly, did you have a conversation with your son about the divorce after you were served with the contempt and found out it was final? Did you?
Yes,
So you did at one point discuss that the divorce was done,
yes,
but that was after you found out from child support.
yes.
No further questions.
All right. Thank you, ma'am. You want to say?
You need to speak up and sit up close to the microphone. State your name, please.
Stephen Matthew Wood.
And are you the former spouse of Miss Heather Wood?
Yes,
Now, you've heard her testimony here today that you and she has this great relationship and y'all were eating dinner, sharing time together regularly. Is that a true statement?
no,
You recall having the hearing here early on where you got temporary custody of your son?
yes.
Okay. And at that time, where did you live?
I live next door to her father.
Okay. And when did you cease living next door to her father?
I moved to Sango or the Clarksville area with our son.
When did you move?
2021?
She said you lived there till 2023.
No,
So that's not true.
no,
Okay. So you moved from there and moved to Sango in 2021. Is that correct?
that's correct.
Now, after that move, did she have a relationship with your son and visit with him?
She would call occasionally and talk to him, yes.
Okay. Now, at the time that this hearing first began, she had an attorney, Jennifer No, is that correct?
Yes, she did.
Okay. And you're aware that sometime later, Ms. No withdrew from representing her.
Yes,
Okay. Now, you recall getting the divorce, in this case, in July of 2023.
yes.
All right. After that, after the divorce was over, what was the frequency of the visits that your wife or ex-wife had with the son?
Your Honor, I object to the relevancy. It's just on the motion to set aside.
Relevance, Mr. McNabb?
Judge, I'm trying to establish how often she talked with the son, but I'll go at it another way. Did she
Overrule the
visit-
objection. I think it's relevant on the issue of her knowledge of the divorce decree and what the parenting plan provisions were.
Did your son talk with her on the phone quite a bit?
He does talk with her on the phone.
So she and he conversed quite a bit after the divorce.
Yeah, they,
Now, a minute ago, you were in the hallway and it was called to my attention from Ms. Crabtree that you were speaking to your son in the hall. Did you mention anything about what he should testify to?
absolutely not.
What did you tell him?
I told him it looks like we won't get out of here. They're going to ask you some questions.
Did you tell him what to say?
Absolutely not.
Okay. Is that all you said before you were,
That is all I said. He's
before you came
hungry.
back
He's
in?
ready to go.
Okay. All right. Now there's testimony from your ex-wife that she lived with your father-in-law, her dad until 2024. Does that sound about right?
She moved back in with him. She moved to somewhere else in between those years of 2021 to 2024.
Okay. So where was she living during the period of time after the divorce?
She has since
In
moved to
July,
Clarksville.
was she still living at her dad's?
Yes, she was.
Okay, and that
She
was
was
in
still
July
living
of 2024.
She was there for about 6 months.
Okay, all right. I think that's all I have. Thank you.
Myers,
I wasn't gonna bring it up, but you did not, you were talking to your son and saying stuff about being questioned in court. And I stopped and got your attorney, correct?
No, you interrupted me talking to my son.
And said, can't talk to your son, got your attorney.
And you said, you can't talk to your son about the case. And I said, I wasn't. I can talk to my son, though.
But you were talking about what was gonna be asked in court.
No, I did not.
Okay. Anyways, so you're,
try.
you agree, you lived in the home with your father-in-law, correct, at the time of this divorce prior to your separation?
Me?
Correct.
No.
Did your wife live in the home with your father-in-law?
Yes.
Okay. You moved in next door with your girlfriend, correct?
For a short period of time until me and my son moved to Clarksville. I lived there for 3 years in Clarksville.
Okay.
21, 22, 23.
What school is your son zoned for?
He is in Cheatham County School.
And you live in Clarksville.
Right.
So you use the address that Miss.
We both decided so he could stay in that school.
Okay.
This is not because she wanted to keep him there.
But you use her address.
Absolutely.
For the school.
Absolutely.
But you've stated to this court, she's not supposed, she doesn't even see him. It's what you stated.
It was for her father, had nothing to do with her.
For her father, what was for her father?
We used that address because it was his address. He was with both of us.
Your son was with both of you.
Her dad. Me and her dad.
Your son
He
went
was
back.
in and out of places.
Okay. So she lived with her father for a period of time, then she didn't live with her father for a period of time, then she did. But your son went back and forth to that address, correct?
My son rode the bus home every day, as he has for 8 years to
So
that address,
He was there every day. Correct.
to ride the bus.
Now, no further questions.
How old are you, Levi?
16.
You understand what it means to be under oath?
So,
Now, you remember when your mom and dad got divorced? Okay. And during the time of before the divorce, where did you live?
For the divorce, I live with my dad.
I'm sorry?
For the divorce, I live with my dad.
Before the divorce.
I live with my dad. Before they were finally divorced.
Where is that?
1096 Fanny Nicholson Road.
Do you know where your mom lived, at the time of the divorce in July of 2024?
Not off the top of my head, no sir, I don't.
Now, but you and your mom talk a lot.
On the phone, yeah, quite a bit.
Okay. What about visitation?
She calls me not regularly, no.
Do you ever recall her mentioning to you about her and your dad getting a divorce?
I do recall her mentioning something about it. I'm not quite sure what it was word for word. It had to do with some time between the time we lived at the new house. So right now, between September, I think it was.
When she talked to you about that, was she like surprised, upset? Did she mention anything about not knowing about it?
No, she just seemed calm.
Okay. She didn't act like it was a surprise.
No, it's just a normal conversation.
Do you remember where that conversation, did she mention to this conversation more than once or just once?
Just the one time that I recall.
You remember where it was?
It was in her car. I think we went to go eat that day.
You know where you were going or coming from?
No, sir, I don't.
But you recall it happening.
Yes, sir.
Now, Did your dad have any influence on your testimony today? He tell you what to say?
No, sir.
When you were in the hallway, did he ask you to say anything other than the truth?
No, sir.
Near the end, the judge focuses on equity and procedure. No valid motion to set followed the no-show, yet a final hearing appeared anyway. That gap matters. Without proper notice, Rule 60's catch-all opens the door, threatening to erase the decree, parenting plan, and reset custody and support disputes entirely.
That's all.
Just to be clear, did she talk to you about that they were getting a divorce, or did she talk to you about it being final?
She mentioned that don't quote me, it's not word for word, but it sounded something like, me and your dad are divorced, right? It had something to do with along those lines.
Okay, and was that while you've lived in Clarksville?
I haven't lived in Clarksville.
Where do you live now?
Coopertown, I think it is.
Coopertown, I apologize. So, well, you live outside Cheatham County, or the Sycamore School District, correct? Okay, and so was it after July 2023? Do you know when it was?
Like the month?
A year?
I would say not really, no.
Okay, no further questions.
Thank you, sir. You may step down. You can have a seat back out in the hallway. Mr. McNabb, we'll call you next witness.
Go the witnesses, Judge.
Any rebuttal?
No, Your Honor.
I'll hear you in argument.
Your Honor, the fact is that in a divorce, we have things that we do. When we're going to set a final hearing and another person is told about a final hearing, like through a motion. She was told through her previous counsel that they were doing a motion to set in January of 2020. I'm sorry, all these numbers are going through my head now. So it was set to be heard on January the 3rd, 2022. They filed the motion in September, set it for January 3rd, 2022, and did not show up. That motion was sent to her previous counsel, and it was never set. Then her attorney comes before the court a month and a half later on February the 22nd and sets a motion to withdraw. It's heard on March 30th. It is granted. We still have no final hearing set. A year later, more than a year later, there is an order entered that is alleged to have been mailed to her address at her father's house. Mr. Wood testifies that Ms. Wood lived there at times and did not live there at times and went back and forth. But Ms. Wood and her father both testified they never received a copy of that order. We have the fact they did not show up for court. This matter was not properly set for a final hearing. She did not know about a final hearing and did not come before this court. Whether she, we have the fact he moved in next door in his girlfriend's house. He was living right there. I don't know where the mail went. I'm sure he was receiving mail from his attorney also. Whose mailbox it went in, I do not know. But my client testifies she did not receive it. They did not come to court to set this final hearing, and the final hearing should be set aside.
Mr. McNabb.
It's undisputed that she was living there at the time she got the letter from Jennifer No. She was living there at the time the final decree was mailed in 2024. She was living there. Rule 60 is clear. Just so that I won't misstate what it says, I'll read it. You probably got it in front of you, but in any event, on motion and upon such terms as are just, the court may relieve a party of the party's legal representation or legal representative from a final judgment, order, or proceeding for the following reasons. Number one, mistake, inadvertence, surprise, or excusable neglect. Number two, fraud, whether heretofore demonstrated intrinsic or extrinsic misrepresentation or other misconduct of adverse party. Those two grounds have to be brought within a year. Within a year. So assuming that's what they're saying, that I did something fraudulent or there's some misleading or something, irrespective of that, it had to be brought within a year, was not. The other ground is the judgment is void. There's no allegation or proof that that's the case in this case. The judgment's been satisfied. The catch-all phrase is for any other reason the court seems just. But in all respects, it's got to be done within a reasonable time. 14 months is not a reasonable time. Number two, there's no proof she didn't get the documents that were mailed where she lived. That's all that's required by the rules of procedure. So
There's no proof that she didn't get them.
there's no proof that she didn't get them.
There's no proof that she did. She testified and her father testified that they did not receive those.
Judge, the rules of procedure say service is complete upon mailing.
It's a presumption.
So that's all.
All right. First, let me address the issues that Mr. McNabb has raised. Rule 60 does provide that there are certain limited methods by which a final order can be set aside or a party can obtain relief from an operation of the judgment. Number one, judgments by default are not generally recognized or not generally favored by the court, especially in a court of equity such as this. This is an interesting case because it is a default judgment that was entered, but it's entered as a default judgment despite the fact that there had been an attorney representing Ms. Woods in the past who had withdrawn and so forth. Rule 60 does provide that must, for certain things, certain bases, I think the number one and number two, which had to do with mistaken inadvertence or excusable neglect, was the first one. And the second one was by fraud, whether intrinsic or extrinsic. Those two reasons have to be brought within 1 year. The fifth provision under that is for any other reason that would justify or justification that the court may find in particular in this case. So that one does not require a 1 year filing if you're proceeding under that. And what that says, for any other reason justifying relief from the operation of the judgment, this the motion shall be made within a reasonable time and for reasons 1 and 2, not more than 1 year after the judgment or proceeding entered thereon. It is this court's opinion that the application of Rule 60.02 subsection 5, any other reason justifying relief from the operation of the judgment, would have to be the only basis by which Ms. Woods could obtain relief. So then we move to, is there a grounds for relief? The testimony has been that she was not aware, her counsel having been discharged, that she was not aware of the fact that there was a final hearing set. It causes this court concern as to how this case became set for final hearing, because as the record reflects in the rule docket, there was a hearing, a motion that was filed to set the final hearing in this case, and it was set for January the 3rd of 2022. That motion was filed in September of 2021. In January of 3rd of 2022, no one appeared. There was no show. And as a result, that motion to set was not heard. And by operation, I think, was basically stricken because of the fact that it was not heard. Then an order was submitted to the court, to me, for my signature, setting a date for a final hearing. The file does not reflect that any additional motion to set was filed. It was simply an order that was entered after it was filed, sent to the court. Unfortunately, there are many times when we have the orders that are sent in that we don't always know, if there's not both lawyers, we don't always know how accurate those orders are. Rule 40 of the rules of the Tennessee Rules of Civil Procedure provides for the setting of cases for trial. Rule 40 states the following: the court shall provide by rule for the setting of cases for trial, A, without the request of the parties, but upon notice to the parties, or B, upon request of a party and notice to the other parties. Precedence shall be given to actions entitled thereto by any statute of the state of Tennessee. And essentially, the comments in that rule make reference to the fact that the provisions for are directory, but the committee felt that circumstances as to the setting of local trial dockets are so varied that this matter had to be left in the trial judges in each circuit or division for their discretion. We adopted the local rules of practice for the 23rd Judicial District. And under Rule 3 of the local rules of practice for the 23rd Judicial District, Rule 3.01 states the following. In the setting of non-jury trials, except for chancery days which may be set by the clerk and master, cases shall be set for a bench trial in one of the following ways. A, by agreement of counsel, B, by motion, or C, by the court with subsequent notice to counsel. In this case, the court finds that none of those rules, none of those methods were adhered to in this particular case, that there was no motion filed after that September 2021 motion that was filed and never heard, that there would have been, to have set properly this case for trial, it should have been a new motion to set, filed, and served upon the respondent in the case. Ms. Wood and her father both testified they did not receive the notice of the hearing or even a copy of the final decree of divorce. And as a result of that, this court is of the opinion that, being a court of equity, that and under the rules, Rule 60.02, subsection 5, that just cause exists to grant the motion for relief under Rule 60. So therefore, the motion for relief under Rule 60 is granted, and the final decree of divorce and parenting plan adopted under that order is hereby set aside, and the matter is returned to the active docket of the court. You will draft an order reflecting the court's findings. So. All right, we're ready then to move back to...
The verdict lands hard. The final decree is set aside, returning this family to active litigation. Years vanish because process matters. This case proves equity can override assumptions of service. For more courtroom reversals, legal lessons, and consequences, like, comment, share, and subscribe so you never miss justice unfolding live.